This is a session on speaking Constitution, an extraordinary book on life and work of K.G. Kannabiran. I will start this session with an excerpt from Sri's poem. Gatamanta tadise raktamuna kaakunte kannilulato చల్లారిన సంసారాలు మరణించిన జనసందోహం అసహాయుల హాహాకారం చరిత్రలో మూలుగుతున్నది. అంతా తమ ప్రయోజకత్వం తామే భువికి అధినాథులమని స్థాపించిన సామ్రాజ్యాలు నిర్మించిన కృత్రిమ చట్టాలు ఇతరేతర శక్తులు లేస్తే పడిపోయెను పేకమేడలై. పరస్పరం సంఘర్షించిన శక్తులలో చరిత్ర పుట్టెను. The essence of this poem by Sri in 3 lines is: history emerged in the struggle of conflicting ideologies or power. This book, Speaking Constitution, is a book which recorded the history of people's struggle to protect civil rights and democracy. And it appears as an autobiography of an individual, but as Kalpana puts it, it is a biography of democracy or biography of civil rights. The period is from early independence to 2010. In this book of 251 pages, only 11 pages are about Kannabiran's personal life. All 241 pages are about struggle, civil rights movement and constitutional arguments in the courts, and how he encountered many challenges in protecting the civil rights of many kinds. That's from poets, writers, to women like Ansari Begum, and the people who are encountered in fake encounters, and Adivasis, minorities, and the leaders like Shankar Guha Niyogi. And also Kannabiran was in many tribunals, like the People's Tribunal on Gujarat 2002. So his life and work both are, a dedication to civil rights movement and for constitution. The constitutional rights, how to make them reach to the people. The journey began in early 70s, and the journey as the beginning was like the defense committee for the Naxalite prisoners. He was a member of the defense committee for the Naxalite prisoners. And before that, in late 50s, it was the case of Ansari Begum. Kalpana will tell about the case of Ansari Begum in detail, because she is a Tamil woman, and at the time of partition, Ansari Begum went to Pakistan because her husband and family went to Pakistan. But she couldn't adjust there, so she returned back to India. But Indian government didn't accept her as a citizen, and Kannabiran fought for her rights. And then only he tried to apply creatively the constitutional rights. In all his life, what he did was applying constitutional rights in a different and creative manner. That may be any case. In this book, there are so many incidences. How he turned the courtroom into a Kavi Sammelan. The judges has to hear the poems of the revolutionary poets, and sometimes he converted the courtroom as a seminar of presenting paper like what is the condition of India as a semi-feudal and semi-colonial country. So, Kannabiran's approach towards law is very different, and people like us and the younger generation should know about this, because we are all now fighting for the protection of our constitution, our constitutional rights. It is the main theme of the book. And before that, Kalpana wrote an excellent preface, an introduction. Without that introduction, this book appears as, for some people it may appear as case after case, one case after the other. Begum Ansari's case, then emergency, and then Shankar Guha and Yogi's murder, and then Gujarat, and like that, one case after other, and how to understand the thread which is connecting all these cases. What is the thread, and how we understand the work of Kannabiran that Kalpana wrote in her preface, and I have to put it correctly. So, the democratic and constitutional spirit of Kannabiran to bring out in a very critical way, Kalpana completely dedicated almost 1.5 years for this book, and I can know how hardly he worked. She explains in detail how he tirelessly argued and concentrated on the directive principles of state policy and his critique of governments interpreting the directive principles as non-enforceable, and how Kannabiran's entire work is a radical critique of governance, and how speaking constitution, this book opens a window into the micro practices of insurgent constitutional practices. These two words, insurgent constitutional practices and transformative constitution, these two are the key words of Kannabiran's work. And Kalpana, in her preface, tried to explain these two key ideas, insurgent constitution and transformative constitution, how Kannabiran practices them. So, we will open it for the speakers, and now I first ask Kodandaram to share his experiences, his ideas as a colleague of Kannabiran in civil liberties movement. You all know Kodandaram as activist of civil liberties movement. So, Kodan.
Good morning. Let me at the very outset ask a question. Do we really need a constitution? The question becomes important and relevant at a time when rulers have to be told that they should conduct Republic Day parade, Republic Day program. That is the context in which we are now talking about the speaking constitution. The book is not about the constitution. The book is about the relevance of the constitution in the Indian context and how this can be used in order to bring about a transformation. Kannabiran looks at the constitution differently. For him, it is not a legal document. Don't look at it as mere legal document. It is a product of the history, Indian history, particularly the anti-colonial struggles. And he explains in great detail how the anti-colonial struggle reflects in the Constitution. Through various cases that he fought in the High Court, not only in the High Court of Andhra Pradesh, but also in various courts all over the country. So his concern was to retrieve that democratic argument that is inscribed into the Constitution. He always says Constitution is not a legal document. Then what it is? For him it is a political statement. A political statement by the people of this country about what kind of a society they intend to build for the future. What kind of democratic system they intend to create in this country. So it is about, retrieving that democratic spirit. And he says again and again that Constitution cannot be seen in isolation from the social and economic context in which we are living. We have to use it creatively, subversively is the word that he uses extensively. We have to use the Constitution subversively in the sense, that the spirit of the Constitution must be understood. The Constitution essentially is trying to plead for the liberation of the oppressed communities. It is pleading for an egalitarian society. So that spirit has to be understood and it needs to be applied in day-to-day life. The application of the Constitution in day-to-day life really unfolds the potentiality of the Constitution. He looks at different instances, different cases in order to explain this. He would say, for example, in the context of the police violence, he would argue that the policemen are also bound by the law. It is so difficult to establish. And particularly in the 70s and 80s, when the civil liberties movement was unfolding, it was very difficult to convince policemen that they are bound by the law. We would go on a fact-finding mission. The policemen would stop us and then they tell us you can't go any further. The officer has instructed that you should not be allowed to go. Then we would argue, that as per the law we also have a right and we can move forward. The policemen would laugh and say, the language is so funny. No one ever told us that we are bound by the law. So this is the kind of a context. At that time, to explain the importance and the significance of the fundamental rights, Bhujja Tarakam, and other lawyer, he wrote a book, What If Police Arrest You? Policelu Arrest Cheste is the title of the book. It sold, thousands of copies have been sold in the state. And people read it so seriously. It so happened on one day, policemen went to an activist's house and they intended to arrest him. This man said, you can't arrest me. You have to show a notice, proper notice, serve a proper notice to arrest. Then they said, how do you know all these things? He showed the book. They tore it into pieces, threw it around, and then they said, where is your law now? So there is no law, we can arrest you and we can take you wherever we want. They pulled him out, dragged him, beaten him, and then they took him into custody. So those were the conditions in which, Kannabiran was acting as a lawyer and as a civil liberties activist. Now, how do you deal with this situation? People who were taken into custody, very often they were tortured and killed. And the kind of torture that would take place in the police station itself, used to be so inhuman. And this needs to be tackled. How do you explain? How do you counter, challenge this in the context of the Indian Constitution? So Kannabiran raised a number of arguments. He would say, for example, that the policemen are bound by the law. Then he would say, in the case of political activists, political activity is not a crime. It is not a crime. All political activities can be countered through a counter movement, but not by converting this into a crime. You can never deal with a political movement. This was a strong argument which he upheld every time. And then he said the policemen are also bound by law. If they have conducted a violated law and killed someone in the custody, then obviously they should also be tried according to the law of the land. Now, to establish this, he almost spent his entire life in the courts, fighting cases at various levels. And finally, the case in these matters went to the Supreme Court, and I think it is still pending before the Supreme Court. The matter related to the encounter. There are many such instances. For example, he would talk at length about the implications of the violence in the police station. It kind of destroys the humanity itself. The person who is subjected to violence suffers the most. But in order to inflict this kind of a punishment, the person who indulges in violence must also lose his humanity. So this is what he used to argue extensively. Then he argued, the cases, the conspiracy cases. He argued on these cases at length in many places. He argued cases in connection with the murder of Shankar Guha Niyogi. What do all these arguments show? He says that the Indian Constitution, Chapter 3 and Chapter 4, they are very significant. And Chapter 3, Chapter 4 are so significant that without that, you cannot make a distinction between Indian Constitution and the Act of India, 1935. So it is these two chapters which give a new life to the Indian Constitution. And this is what he upheld during the course of the emergency. In emergency, everyone said, once a presidential rule is imposed, you cannot challenge the arrest of a person in the court of law. Kannabiran disagreed. He said, yes, this is not correct. He argued that the rights are prior to the Constitution, particularly the right to life. Right to life is prior to the Constitution. It is inscribed into the Constitution. That does not mean the Constitution, by converting this into a legal right, we do not impose limitations on this important constitutional right. That right is unfettered, and that right has to be enjoyed in conjunction with the other rights. So he argued in the court, if those rights are so important, prior to the Constitution, no other, and they are fundamental to the Constitution, constitute the basic structure of the Constitution, you cannot, under any circumstances, suspend them. So the presidential order merely suspends our right to go to the court. But then he said it doesn't suspend the other fundamental rights. So what happens? Other fundamental rights are in force. So any order that is issued to suspend the fundamental rights must be in tune with the fundamental rights chapter of the Constitution. It cannot be violative of the fundamental rights chapter of the Constitution. This is what Khanna also gave in his minority judgment, argued it later, much later. But before that, Kannabiran has raised this issue. Khanna also more or less, H.R. Khanna has also more or less gave the same judgment. He said in his judgment, the right to life is not suspended. How can it be suspended? Because this is so fundamental to our existence as human beings. It is prior to the Constitution, a natural right. that can never be suspended. So then he raises a very important argument. He says that any order that suspends the fundamental, that deprives life and liberty, must be in tune with the fundamental rights. It cannot be any law. It cannot be any law. It has to be a law that is in tune with the fundamental rights chapter. So if it is violative of the fundamental rights chapter, then that law can be set aside. It will be void according to the Constitution. So these were the arguments that they have raised, put forth, subsequently accepted by the Supreme Court, and they now have become the fundamental tenets of the fundamental rights chapter in the Indian Constitution. Reading them together is also another important dimension. Reading fundamental rights and directive principles together. So there are many such instances. It is it helps us to read the Constitution in a different manner, in a more lively fashion. I hope you would all read this book, and it is kind of not merely the life and quote arguments of Kannabiran. We are dealing with life and times of the post-emergency and the Indian, civil liberties movement, life and times of the struggle for democracy in India. It is a wonderful reading. Kalpana has edited and translated the Telugu version. Telugu version, 24 Gantalu itself is hugely popular, and now it is translated with a beautiful introduction that illustrates the significance of these activities. I thank the organizers for giving me this opportunity.
Thank you, Kodandram. Now, Kalpana, will you share your experience of editing and translating this book and writing a preface? You can also read some parts of the book which will be interesting to the readers.
Thank you, Volga. Thank you, Volga. Thank you, Volga, and thank you all for being here, and to HLF. Problem. Thanks to HLF for inviting us to discuss this book in this forum. It's always special. And I must also say that for me, sitting under this tree at this stage is an extremely emotional moment. I have two daughters, and I spend 20 years every year in this very space. So it's a comfort zone for me. Where this book is concerned, I think, I was actually wondering where to start. Kodan and Volga have both given a broad sweep introduction to the book itself. I wanted to actually take a slightly different route. I will read from parts of the book, and I wanted to take a slightly different route to why I embarked on this. What did I hope to do, and what did it mean for me to do this work? I will also read excerpts from different chapters so that you get a sense of his voice and his own engagement with different sets of issues. The first thing I wanted to do, K.G. Kannabiran was my father, is my father. I'm always confused whether to speak of him in the past or the present tense. He was also the person that I was most closely, emotionally and intellectually welded to. So, this book was not, just an objective task that I undertook to put his work out. it required a lot of effort on my side to actually make a distance, to create the distance in order to be able to reflect. So I begin with an observation that I have often noted and have shared with children of people who are known. There is in the normal course an invisibilization of children, of leaders of different kinds. They may be political leaders, they may be leaders in any realm, but if you are known, then there is an invisibilization of children. It's almost like they are part of the walls and furniture, so nobody particularly notices them. But children notice the work that is happening in the home. They notice people who are coming and going. They hear the stories and they absorb them in very different ways. And so I will begin with a few lines from my preface, and also a word on why I wrote the preface a little later. When emergency was declared in June 1975, I was 5 months short of my 14th birthday, with a mysterious new board exam, tougher than ever before parents and students were warned. Mine was the first batch of the ICSE in November-December 1975. In the fancy dress event organized as part of the school's Teachers' Day celebration in September that year, I wore a white cotton sari, powdered my cropped hair, put on a pair of borrowed spectacles, and read out Indira Gandhi's speech declaring emergency. I have a vivid memory of myself reciting the opening lines of that speech. The President has proclaimed an emergency. This is nothing to panic about. I do not remember discussing what I would do at home. In fact, I don't recall any conversations except about how I would cross the hurdles of this monstrous exam, with my teachers worried that I would dent the 100% pass figure that every school desperately wanted. Like my parents, I was a mediocre student with no aspiration to excel in school. My mother vexed the teachers at the last parent-teacher meeting with her nonchalant response that she was not really concerned with the school tally. She was caught in a cusp. My father clearly was busy keeping another tally, as is evident from the accounts in this book, of prisoners, of those detained in jails, in illegal detention facilities, and those being shot in encounters. In the midst of this, my sister Chitra, a year older, was tasked with chaperoning me and glowering at an aging rogue tuition master with roving hands, who was entrusted by my somewhat harum-scarum mother to teach me math so that I could catch up with the syllabus less than a month before the exam. On my 14th birthday that year, 1st December 1975, in the middle of my board exams, Boomaya and Kishtagod were hanged in Mashirabad jail in Hyderabad. My parents had both spent the previous night on the pavement outside the jail and returned home that morning on my birthday after the execution in deep mourning. So there is a sense in which the experience of absorbing the violence of the state, narratives of state violence, narratives of the trauma that take place in the presence of children, get absorbed into consciousness and are recalled at the most unexpected moments. I have thought many times, why did I go back to the emergency? Why did I enact Indira Gandhi? There were many leaders. Why Indira Gandhi? Why the emergency speech? But these, I think, are the way in which children, an absent presence in a sense, make themselves present in their own familial context. From there, I move to the introduction, which both Volga and Kodand have mentioned. The introduction is in the English volume, and it is a result of a very, very long intellectual engagement, a long and a close intellectual engagement that I had with my father over several decades, while being a total outlier in the movements that he was part of. I was never part of those movements, but I was part of the conversations around the movements on questions of law, on questions of jurisprudence. And what I tried to do in the introduction is to present his work through the sensibilities that I had acquired through innumerable conversations and anecdotes that I heard from him and that I spoke with him about. The challenge, of course, was for me in the translation, because I'm not a practiced or a habitual translator. The challenge in the translation was to migrate the text from a rich anecdotal reminiscence to a treatise on the Constitution and the rule of law, while retaining the richness of the anecdotes and the reminiscences. So how do you layer that voice? Because my concern also was that if somebody picks up the text, it should be possible for them to immerse themselves in his sources. Why is he saying this particular thing about this particular case? Why is he saying that this commission of inquiry was either not represented properly in the media or was represented properly in the media? So the two major sources that I have included in the English translation are an extensive citation of case law, where almost every single case that he mentions is cited so that it is traceable. And the second is to provide a very heavy archive of media reports on civil rights violations. Which incident was reported in which paper and how? Because it's important at this point for us to go back to sources and for us to be able to grapple with those sources. And of course, in the entire book, and this is a point Kodand drew to my attention when we had the formal launch of this book a month ago in Hyderabad, that what the book actually opens out to us is the strategies and the methods that should be employed by a human rights lawyer. If you are a lawyer who is committed to human rights, how do you understand and apply the law in day-to-day matters in courts? And in that sense, I think that this book serves as a kind of a ready reckoner or a guide to practicing human rights lawyering. So I was very keen that students across the board, across disciplines, and lawyers, young lawyers especially, and law students, should be able to access this text on a very different register. One of the things that he says in the memoir is that he does not want the memoir to be a story of his personal life. He wants it to be a story of him as part of struggles, of him as in conversation with social movements. And so, barring one section of the opening chapter, which really talks about his childhood and his youth, there is nothing in it that reflects on his personal life. I suspect it also had to do in the fact that he was very, very unlike my mother in that sense, and I am very, very much like him in that we fiercely guard our private. There was no sense in which he allowed anybody a toehold into his private life or into any minor say in decisions about his private life and his children. And I think that is really what I valued a lot about the way in which he understood the business of fathering. Because that is what actually threw a shield around us and enabled us to grow in very different ways. The one incident, we were talking about the police in the last session. Kodan spoke about the police. I want to read to you an excerpt of an incident he recalls in 1982. I quote, "My memory goes back to 1982. Justice V.M. Tarkunde and I were in Madurai on 31st October 1982 to participate in a public meeting in the forenoon, followed by a silent procession in the evening around 5 p.m. After the meeting, around 4:30 p.m., the processionists gathered near a huge statue of Muthuramalinga Thevar, a well-known leader of the Thevar community in the 1950s. Tarkunde and I were in the first row leading the procession, and it was a silent procession. We had black ribbons tied over our mouths. Among the processionists was a journalist with a camera. As we were getting ready, a contingent of over 100 riot policemen arrived in vans and stood in a row in attention, staring menacingly at us and awaiting orders. The journalist took a few shots of the processionists, and when he began taking shots of the police force, the inspector objected and ordered him to surrender his camera. As he refused, force was used to secure the camera. The journalist, dodging attack, came running to us, seeking our protection. The inspector too came running towards us. The conversation that followed between Tarkunde and the inspector ran somewhat along these lines. Tarkunde: "Why are you chasing the young man?" Inspector: "He took photographs of the police force, which he cannot do. He must surrender his camera." Tarkunde: "Which law restrains a person from taking photographs of the police force?" Inspector: "The provisions of the CRPC, the Code of Criminal Procedure," and he's saying this to a judge. Tarkunde: "I have been a judge of a high court for quite a few years and had occasion to deal with the CRPC. Which section of the CRPC restrains a person from taking photographs of the police force sent to regulate a procession?" The inspector, on hearing the credentials of Mr. Tarkunde and finding himself inadequate, called upon the additional superintendent of police, Mr. Mohammed Ali, to deal with Mr. Tarkunde. The additional SP, guessing that Mr. Tarkunde was not from Madras, bluffed to him that the Madras police standing orders restrained the taking of photographs of a police force sent to regulate the procession. I intervened and said I had some acquaintance with the standing orders and asked him for details. I said this in Tamil. Mr. Mohammed Ali thought, enough is enough, and immediately turned around to the police force and ordered them in Tamil, beat up the bastards. Mr. Tarkunde and I, along with others, were thrashed, put into the police van stationed nearby, and carted to the police station. We were made to stand in a row before the station writer's table, and our names were recorded in the register. Mr. Tarkunde was the first accused. So this is after the emergency, this is after the Bhargava Commission, this is after the Shah Commission. We are talking 1982. So when we are speaking about state violence, whether it is 1982, 1975, or 2019, when we had the encounter in Hyderabad, we are talking about the need for citizens to actually be able to stand up and confront the police with a knowledge of the law. And of course, the fact is that even that knowledge of the law is unlikely to save you from being thrashed by the police. But just because you're going to be thrashed anyway, and this was Kannabiran's major argument, just because you're going to be thrashed anyway, or you're going to be arrested anyway, doesn't really mean that you abstain from a knowledge of the law. Can I read one excerpt from the time? Okay. There's one more excerpt that I'd like to read for you, and this goes back in time, goes back from 1982 to the emergency cases, where several, countless, hundreds of people were arrested in Hyderabad. Members of the Jamaat-e-Islami and RSS were also arrested. There was a young boy, 15 years of age, by name Bhavani Shankarudu. My last petition in emergency cases was filed on his behalf. He later became a leader of the Bharatiya Mazdoor Sangh. One day, after arguing a habeas corpus case in the court of Justice Sambasiva Rao and Gangadhar Rao, I came out and lit a cigarette. Those were the days when you could come out and light a cigarette. This was soon after the Supreme Court ruled that MISA was valid law. Bhavani Shankarudu was produced in court. When the judges asked him who his lawyer was, the young boy said, Kannabiran. He must have been instructed to do this in jail. The judges immediately said, Kannabiran has just left the court hall. Call him back. I went back in. Taking one look at the boy who had not yet grown a mustache, I said to the judges, if the law says that a boy like this poses a threat to internal security, it is a useless law. The government pleader stood up and stated to the bench, even before he was asked his opinion, that these detentions should simply be confirmed in the light of the Supreme Court judgment in the MISA case, and that there was no need to argue the case. I turned to him with a repartee. I don't think you have become a judge yet. I would be quick to respond in every situation like this brought to me before the courts. And then, of course, there was the case of Advocate M.V. Ramamurthy, also a civil liberties leader, which was even more unusual. He asserted that he had the right to have intimate relations with his wife. This was his writ petition. He had a right to have intimate relations with his wife. The emergency had not struck down that right. Therefore, he argued that his right to sexual intimacy must be protected and he must be permitted to be with his wife at intervals. When he filed this petition, he was around 60 years old. He was a humorous person. This petition came up before Justice Chennakesava Reddy and Vadari Venkatramaniya was the amicus curiae. Although his petition was dismissed, it generated a lot of debate. So you can clearly see, and this is something that you can see throughout the book, that there was humor, there was laughter, there was absolute disobedience, and there was a complete refusal to bend before an authoritarian government and an authoritarian state. And I could actually just keep multiplying instances. But I will just conclude with my final observation. The Telugu original, Irvenal Gantalu, actually has a very long foreword by Vasant Kannabiran, which is titled Kannabiran to Ardha Shatabdam, Half Century with Kannabiran. This was written originally in English and published in translation first in Telugu. She later published it in English in her book that came soon after his death, A Grief to Bury. I did not include that foreword in this because my purpose in this translation was very different, and also that essay had already appeared in English and Telugu. But what I did, because as someone who's been feminist since her teens, one of the first things I learned was on the criticality of reproductive labor and the need to recognize reproductive labor in reproducing the labor force, mental, intellectual, manual, from day to day and over generations. And none of the enormity of the work of Kannabiran really strikes you when you look at this. But none of that would have been possible if he did not have the guarantee of an equally or even more enormous emotional and reproductive labor that enabled him to get back on his feet and out there in courts, in tribunals, day after day, for 50 years, with his enthusiasm and his commitment undiminished, if he did not have the guarantee of the reproductive and intellectual labor and caring that he had the guarantee of. And so the way in which I translated that was to offer a dedication in this book, which says, for Vasant Kannabiran, her story, his story. To an ordinary reader, it might appear as if it is a loving, emotion-filled dedication of a daughter to her mother. It is everything but that. There are no heart and smooch emojis here. It is a dedication to Vasant Kannabiran, who was responsible for ensuring that Kannabiran actually returned to work every single day after he returned back from work. And that is what, in fact, kept him there, kept his sharpness alive, and kept him on course for 50 years through his court walk. Thank you.
Thank you, Kalpana. I want that should be the last sentence of this discussion. But if anybody wants to ask questions, I will open for questions for 5 minutes.
Hi, it's wonderful listening to all three of you. I just wanted to share something that happened recently which really made me feel very sad and very, very angry. At our community Republic Day celebration, our community housing society's president, he said the constitution has to be changed and should not be, we should have a new constitution because it is not removing hunger from the country. And he said this is, and he was so very, convinced about his argument that it is not, it is the constitution which is responsible for hunger in the country. And I was wondering how this new conversation about changing the constitution or not changing but replacing the constitution with a new constitution is being taken by common people, without much thinking. And I feel that there is a real need to make people aware of what constitution stands for and why it is so important for us. I think books like this and also, but there should be more conversation at the common people level because they just get carried away by the propaganda.
That's the comment, I think. That's the comment. Anybody?
Good morning, ma'am. My question is from the idea that there was a conversation going on a bit before this session about how freedom movement was all about Oxford and Cambridge written lawyers. Similarly, as a law student, from the books that we have read, it is also talking about how Constitution has served as a document mostly for the elite, because it was more accessible for the elite, which I disagree with. The reason of disagreement comes from the idea that Constitution also has been a very important platform for a lot of marginalized groups, but this is not well written, or this has not been captured whether in literature or movies. So my question is, how is your book different from the book that's already written on Constitution, and does it also capture these marginalized groups, these groups who are not otherwise talked about in a lot of other literature?
Very briefly, having also taught in a law school for over a decade, constitutional law in law schools don't teach you the Constitution. They don't teach you constitutional morality. They don't teach you the spirit of the Constitution. The Constitution does not serve the elite. A rudimentary reading of the bare Constitution will tell you it does not serve the elite. The Constitution is about protections, for substantive protections for those who in the power balance are at a disadvantage, particularly at a structural disadvantage. And I urge you to read this book because you will not find the elite circulating in this book.
Just one line. It also tells you how to reclaim the Constitution in the present context, make it much more relevant in every day. In fact, the last 2-3 years, every social movement is now using a copy of the Constitution to defend its position. So it is already becoming a part of the mass movements, and it is also becoming a part of the day-to-day civic culture. So it would be good if we can reclaim it through books like K.G. Kannabiran's Speaking Constitution.
This book is very, very relevant because every case in this book is repeating itself. Ansari Begum case about citizenship. Now hundreds of men and women are struggling to establish their citizenship. And imprisonment of poets and writers. Now Varvar Rao and many other intellectual writers are in prison. And encounters, the situation came that people are applauding for encountering young men by the police, and minorities and Dalits flight from 2002 to 2023 is falling down and down. And Adivasis, we all know how they are struggling about their own land rights. So this book is a very, very relevant book. You use it. You use Constitution, and you have to read this book, how to apply Constitution in your daily life and also in the lives of oppressed people. Thank you.
Thank you so much, Volga Garu. Kalpana Kannabiran and Kodandaram. Thank you so much.